Well, good morning. This is exciting. Welcome to the Great Hall. This is a spectacular room, and it's a spectacular group of people assembled. I am deeply humbled to be in the presence of so many esteemed, talented, and dedicated competition law enforcement officials from throughout our country and throughout our world. We are gathered here in the Great Hall at the Justice Department. And today, the Great Hall is most certainly living up to its name. Today's collection of antitrust and competition law enforcement authorities from around the world and around our great country are here today, gathered in person for a one-of-a-kind event. Just this morning alone, we will hear from leaders of the United States, the UK, South Africa, and the National Association of Attorneys General. In total, we are joined today by senior officials from 30 global jurisdictions, 21 states, and the District of Columbia. And we are joined today, this morning, by a live-streamed audience of a public that rightly demands solutions to the problems of monopoly and oligopoly. We meet at a time when a popular movement is growing in support of more robust competition enforcement in the United States and around the globe. Our fellow citizens who are feeling the effects of monopoly power are advocating for greater protection of markets and opportunities to compete and benefit from competition. So let me start by saying this isn't just another conference. This is a chance for expert enforcers confronting similar challenges to exchange ideas and collaborate regarding the path forward at a time when our markets are experiencing tectonic shifts. I know I speak for my co-host, FTC Chair Lina Khan, and our colleagues at the FTC when I say that we are eager to listen and we are eager to learn. We are experiencing a change in our economy that is on par with, if not exceeds, the Industrial Revolution. The ideas of competition policy are timeless, but only if we are willing to adapt the familiar tools of competition to keep pace. Poles and wires have given way to ones and zeros. Intermediaries that once protected against information sharing have given way to digital collusion. Data has replaced oil as the power source for our new industrial tools. The models of the smokestack economy reflected in simple geometries of the physical world. They used to be reflected in the physical world. Goods used to move up and down supply chains. Competitive relationships were vertical and horizontal. Those facts have changed. We have platforms that are multidimensional, serving distinct users and businesses all at once with complex relationships. The geometries of our markets today often look more like gemstones than two-dimensional drawings. Gatekeeper power has become the most pressing competitive problem of our generation at a time when many of the tools to assess and address gatekeeper power have become outmoded. But we're working to meet the moment. The group assembled today in this great hall is not sitting by idly. Together, we are not just advancing the dialogue, but we are adapting our tools. Analytical frameworks and internal expertise with the courage and creativity to protect competition for generations and generations to come. Look around you. We are surrounded by enforcers who are confronting the necessity and boundless opportunity of modernization on a daily basis. Not just through papers and panels are we confronting these issues, but through the hard work of investigation and enforcement. To be clear, this is not an academic conference. This is an enforcers summit. In the United States here, for example, we are invigorating monopolization and merger enforcement. The deterrent effect is powerful, and the results are most certainly tangible. Simply put, Most anti-competitive deals are no longer getting out of the boardroom. And the ones that do are facing a sophisticated and empowered team of career enforcement officials who are ready to examine market realities and who are up to the tough but noble task of protecting our fellow citizens from the ills of anti-competitive mergers. And would-be monopolists know that the antitrust agencies are standing by to challenge exclusionary conduct. When it comes to monopolization, for example, we have more active litigation and investigations than several prior decades combined. As a result, the economy is rebuilding itself all around us. Little by little, day by day, the natural forces of competition are taking root and building competitive markets. That was the genius of our respective legislators in passing competition laws and rules in the first place. When we stop anti-competitive conduct, prohibit exclusion, and stop mergers that risk lessening of competition, we let natural forces of free and fair competition elevate our economies and our democracies. So let me open this extraordinary conference with a note of optimism. Our work is making a difference. We have already changed the calculus for businesses contemplating preserving their power through mergers or exclusionary conduct or cartel behavior. And as a result, we have reopened markets for competition to gradually appear and flourish. But as we confront the pivot to AI and new paradigms of healthcare, finance, and agriculture, I'm incredibly hopeful. So long as we continue to build on and maintain appropriate enforcement that accounts for modern market realities, new technology will bring a new competitive reality to our economies. And today, I hope we can learn from each other how to continue that success. We will open the morning with a public broadcast of interviews and panels, and I want to make a request about that. The audience, you, are designed to be a part of this event. And so please, step forward with your questions. We will leave Q&A opportunity at every panel and every session to make sure that we can engage with each other. Before we begin, I want to acknowledge a lot of effort that's gone on to pulling this event off. I want to thank the staffs of the Antitrust Division and the Federal Trade Commission who worked tirelessly to make today's event happen. In particular, our International Section Chief, Linda Marshall, Competition Policy and Advocacy Chief, Karina Lubell, Special Counsel for State Relations, Sarah Allen, and International Counsel, Becky Valentine. We also have an extraordinary group of FTC personnel gathered: Cynthia, Patty, Jill, and Maria. We all owe them a debt of gratitude. And there's so many more. And so I would like, if you indulge me, to ask anybody who's had a hand in planning today's event to stand up so that we can thank you for your extraordinary efforts. I'd also like to take a note of privilege, if you'll indulge me. I'd like to introduce someone who needs no introduction, but to many of you, our newest official at the Department of Justice Antitrust Division, our newest Deputy Assistant Attorney General for Criminal Antitrust Enforcement, which we effectively call the CRIMDAG, and one of the most significant and coveted roles inside the Antitrust Division. I could not be happier to introduce Manish Kumar. So with that, it is my absolute privilege and distinct honor to kick off today's second annual Antitrust Enforcer Summit, which I will do with my pizza pen, in case anyone's wondering. And I'm going to do that by introducing two extraordinary individuals. Last year, I talked about how we have a bona fide rock star in our midst here in our antitrust world, and it's my privilege to raise a candle or a lighter for my colleague and friend Lina Khan, chair of the FTC, and our former CMA head Andrea Coscelli. Please welcome them and welcome to our summit.
Great. Good morning, everyone. Jonathan, thank you very much for the kind introduction, and thanks to colleagues at the DOJ and FTC for this great event in this beautiful room. So I have a few questions for Lina on a number of topics I think are of extreme interest to all of us. I would like to start with your enforcement agenda. I read your Fordham speech, which was really interesting about going back to the statutes, going back to the spirit of the legislation, and really trying to direct the enforcement agenda that way. And that's something, to some extent, I tried to do during my tenure at the CMA. And obviously, that's very helpful in terms of changing the risk appetite for the agency, trying to avoid the kind of self-censoring problem, which I think most enforcers sometimes feel they have. But then, if you think about the reality of litigation and courts, I mean, if I look at my own experience, if I look at the discussions now compared to when I started in 2016, the court cases feel very similar. So there is a sense that enforcers have been on a journey, tried really to understand the modern economy, move on with the times, but sometimes then when you're fighting in court, you don't see that. So you're sort of nearly 2 years into your tenure. So what's your reflection so far on that?
Thanks, Andrea, and it's really terrific to see all of you. Thanks so much to our partners at DOJ for hosting and all of the FTC and DOJ staff that put this event together. Really looking forward to the day ahead. And it's really especially exciting to be here with Andrea. Last year we were switched and I was interviewing Andrea, who'd had a remarkable tenure at the head of the CMA and really made a whole set of programmatic advances that we at the FTC are looking at closely, learning from, and in many ways we really shared core agenda items. So a key pillar of what we're looking to do at the FTC is make sure that we're fully activating and moving full steam ahead with our full set of tools, the full set of authorities that Congress has given us. Fidelity to Congress and to the text of our statutes is paramount. And unfortunately, there's been, a tendency at some points in the past to really conflate some of these authorities or collapse them in ways that we're really taking care to disentangle and make sure that we are appropriately activating each one. So there are a few areas that have been a key part of this focus already. A big one has been Section 5 of the FTC Act. So Section 5 of the FTC Act prohibits unfair methods of competition. This is really the heart of the FTC Act. It's the FTC's reason for being. The FTC was created not to be a duplicate of the Antitrust Division, but to really serve as a complement. And this Unfair Methods of Competition Authority was a key part of that. The understanding being that it extends beyond the four corners of the Sherman Act and is really supposed to function as a gap filler and enable us to be able to reach forms of conduct that we believe constitute unfair methods of competition. And it was the Congress's idea that the FTC, as an expert agency that would regularly and routinely be closely studying markets, understanding new business trends, would be updating how unfair methods of competition was applying in the economy, since we would be dealing with an evolving set of market realities. So we were able to publish a policy statement at the latter half of last year that lays out what unfair methods of competition means. This project really involved mining through a century of case law. We understood what have the courts actually said about this authority and what are the core principles that we can be sharing with the market and with the public as we move forward with reactivating this. So that's a core one. We've also been looking carefully at all of the provisions of the Clayton Act. So we've been looking at Section 3 of the Clayton Act, which in the past has sometimes been collapsed onto the Sherman Act, but actually prevents types of exclusionary conduct that may differ and where you may not have as high a burden. So we, in our case against Syngenta and Corteva earlier this last year, were able to include a Section 3 count, which we think is important for erecting Section 3 as separate from sections of the Sherman Act. We've also been looking closely at the Robinson-Patman Act. So this is another, of course, antitrust statute that Congress assigned the FTC to be enforcing. We're looking closely at areas where we might be able to do that in short order. One of the key provisions that we've put the market on notice about is Section 2C of Robinson-Patman, which prohibits illegal kickbacks and rebates. And in particular, we've heard some concerns about ways in which relationships between PBMs and the big drug manufacturers may raise concerns under this provision, and so that's something we're looking at closely. But across the board, we're really keen on, being as faithful as we can to the text and making sure we're activating all of these authorities.
Great, thanks. And in terms of, obviously when you decide what to challenge, there are many factors going into it. To what extent do you think about the risk of creating a recent legal precedent you don't like in the assessment?
Yeah, look, this is a risk that weighs heavily on all of us. I'm sure we can all relate. It's something that we think about day in, day out. And we have to be sensible, and we have to be smart and make sure we are assessing which cases are the right vehicles for moving ahead. I think one thing that's been top of mind for me is making sure that we're not just weighing the risk of moving forward with the case that might not be the best vehicle, but also weighing the risk of not acting. There's no doubt that in market after market in the US, we see major competition problems, and the problem is urgent, and we need to act. I think one pathology that sometimes we can fall into is convincing ourselves that we need to wait for the most immaculate set of facts ever to arise before us before we can move forward. And I think if that's the only thing that you're prioritizing, then year after year can pass, and at the end of the day, you can really fail to take a shot at all. And so one thing that we're really focused on is not just the cost of creating bad precedent, but also the cost of not creating any precedent at all. And I think one real cost of that we're living with right now is stale doctrine. If you're not really pushing the courts to engage with how these statutes apply in the new economy, you get doctrine that is stale. And I think that's something that we're seeing head on right now, and so we feel a real impetus to be moving ahead. One case that comes to mind here is MediWithin. That case did not come out the way we wanted. We wanted to win. We thought we had the facts to win. And we were unfortunate that the court saw it a different way. That said, that opinion has a whole set of justifications and explanations that really do mark a programmatic advance for us. So this was a case that we brought alleging potential competition harms in the context of a nascent market. And the judge said a few things. He said, the fact that you might have rapid entry does not prove that there isn't concentration in this market, right? That's significant. I think oftentimes what we hear from defendants, especially when they're looking to merge, is that, there's a lot of fluidity, there's a lot of dynamism, and so there's no concentration problem. The court said, no, there might be a lot of entry, you might be seeing a lot of activity, but that doesn't change the basic fact that you have a basic level of concentration, and that has not been dislodged whatsoever. The other thing the court said was, we basically used both the practical indicia of Brown-Shoe as well as the hypothetical monopolist test. And the court said, you actually don't need to do both. If you are making the case just on practical indicia, and that's making your case for you, we don't actually also have to look at the hypothetical monopolist test. That was significant for us. The court also said that reasonable probability is enough as a standard when you're trying to assess the likelihood that the firm would have served as a potential competitor. That, set a lower standard for us than what some other courts have adopted. And more generally, we showed that the potential competition doctrine is alive and well, right? Meta was arguing that this is a stale doctrine, it really doesn't exist and shouldn't be applied in this market, and the judge forcefully rejected that. So I think that's a good example of a case that didn't go the way we wanted, but really did lay out a map and showed the way for continuing to bring potential competition cases, especially in digital markets and especially in nascent markets.
And how do you deal, one of the issues we have in Europe is there are some precedents from the 70s who are potentially very helpful for enforcers, but then you're in court and, the companies are saying, well, modern economics, there was no economics in those cases. So there is a very heavy discount on older judgments. So you always have this asymmetry where more recent judgments, in a sense, carry more weight. So when you do the type of exercise you have done, where you go back and you look, quite forensically to a longer period, I mean, what's the best way for enforcers to try to convince, in terms of the narrative, trying to convince judges that you need to kind of widen the lens and go back in history a bit more in terms of the precedent?
Yeah, I think that's absolutely right. I do think it can work. It can work both ways, right? I mean, as lawyers, we're always, either arguing by analogy or disanalogy, and depending on what the old case says, we can be opportunistic in either direction. I think in many instances, some of the core concerns were the same, right, in terms of concerns about, coercion in the context of our Section 5 unfair methods of competition authority. A core concern was whether a firm is acting coercively or exploiting its power. That's something that, the opinions may have been offered in the context of dramatically different markets, but remains a core concern in digital markets, where you have such outsized asymmetries of power, that a single firm really can call the shots and really dictate what's happening in an entire market. So that's something we look at closely. I would say more generally, I think there has been a tendency to ignore a lot of the case law that is on the books. This is Supreme Court precedent. It's alive and well, and our job as enforcers is to follow the law on the books, rather than say to decide that, that doesn't fit our contemporary predilections. We think it's not sensible or not smart, and so I think we at least have to be trying to faithfully follow the law that's on the books.
Yeah, no, I think that's very powerful. On Section 5, I mean, I understand some of the states also have similar statutes. So how do you work with them, or you try to leverage kind of your combined sort of firepower?
Yeah, the states are really important partners to us. It's a partnership that we really value and have been continuing to nourish. As you noted, the states have what can be sometimes called mini FTC acts, where they both are prohibiting unfair or deceptive acts or practices, as well as around, I think, 21 states have unfair methods of competition prohibitions as well. Various states, follow the FTC Act and the precedent set by it to a variety of degrees. Some tend to really owe a lot of deference, some less so, but one thing we did when we were rolling out our Section 5 policy statements was actually work closely with the states to explain to them, this is the statement we'll be putting out. We hope it's something that you all can really benefit from and use as well. Some areas that we've already used standalone Section 5 are areas where the states historically have been very active as well. So 2 sets of enforcement actions that we brought addressed non-competes. Non-competes in the context of security workers, low-wage workers, where firms had really locked up security guards for a 100-mile radius for a couple of years, and we alleged that was an unfair method of competition. We also brought a Section 5 unfair methods of competition case in the context of non-competes that had been used by glass manufacturers. So the glass manufacturing industry in the United States is highly concentrated, and one concern that we had heard was that these non-competes were being used in a way that were locking up very skilled workers, and were, as a result, blocking entrants that were well positioned to enter the market. But even though they had been able to, raise the necessary capital, build the necessary factories, they realized that the workers with the right set of skills and training were unavailable to them because they were locked up. And so that's another instance in which we were able to bring a Section 5 action. The theory there being slightly different. In the security guards context, the theory was the unfair method of competition was the result of an exploitative act, a coercive act, because you had such an extreme power differential. In this case, though, it was really the aggregate competition harm that was arising that was keeping this market locked up. So that's an area where the states have been very active. There are a whole set of states that have either prohibitions or significant limitations on how non-competes can be used. So that's another area where I can imagine us working closely.
Great, thank you. On sort of thinking a bit about some of your programs and the sort of public listening exercises you have been doing, I mean, that's again an area where we're doing something similar in the UK, and I think you've done a great job here. Because it seems to me as an enforcer it's really important, and you're out and about and you meet lots of people who would regard the kind of cost of hiring lawyers coming to London or Washington, whatever, as too much. And so in a sense you really need to understand their issues, the kind of almost the barriers to entry for them to complain. I mean, can you tell us a bit about some of these the encounters, some of the discussions with small businesses, and sort of your sense today of the extent to which the system is really helping small businesses in the U.S.?
Yeah, this is something that's really close to my heart and really important, and something we've been prioritizing at the FTC. I got my start in this field as a journalist, as a researcher who was basically tasked with saying, here's a seed merger that was approved. Here are all the justifications that the companies offered. Here's what the enforcer signed off on. Go talk to the people in the field and understand, did it deliver all the benefits? And, talking to the farmers, talking to the actual people who were market participants there, became clear that in all sorts of areas, unfortunately, there's been a tendency to really buy into theoretical assumptions about the types of benefits that will result from mergers that the people living in these markets have not felt whatsoever. And so one thing that was really important to me from the get-go was making sure that we're not putting on blinders and just hearing from, lobbyists and the big defense firms and their clients, but really understanding what is the day-to-day lived reality of how market power is manifesting in these markets, to make sure we don't have blind spots. So at the FTC, we've done a few things. We have monthly open commission meetings where we'll have agenda items that we're voting on, but for each meeting, we also have a period where anybody in the public can sign up and come talk to us directly as commissioners. And that's been enormously enlightening. We hear month after month from people who are having to ration their insulin because it's too expensive. People who are reporting, loved ones who have died because their medicines are too expensive. We're hearing from gig workers who are reportedly being, exploited by the dominant gig platforms. We're hearing from franchisees who describe an asymmetric relationship between franchisors and franchisees. And, this does a few things for us. It can put issues on our radar that might not otherwise have been ones we were aware of. But it also really increases the urgency.
Yeah, exactly.
I think when you're directly hearing from people about these tangible ways that monopoly power is personally affecting them, sometimes with life or death consequences, it really makes you, think twice as an enforcer, and underscores the high stakes of all of the decisions that we face day in, day out. And I think, again, underscores the real costs of inaction, both with regards to not addressing these problems in the market, but also with regards to fueling an unfortunate disillusionment that a lot of people have that government is not really working for them and not on their side. And so that's a burden that we also carry, making sure that we as public enforcers are working for the public and, good models for actually fighting for them and making sure that that's clearly seen and heard.
Yeah, I completely agree. I think it's very energizing as well for the agency, for staff. I mean, the fact that you're working on things which have a direct impact, you get a sense of urgency, because otherwise some of the cases we do, this kind of multi-year litigation exercise, which can feel at times a bit detached from the day-to-day reality. So I think it's really, really important. So I'm really glad you're doing it more than we were doing, but I think it's really, really important.
Yeah, it's something that we also prioritize as we've been going through the revision of the merger guidelines. So DOJ and FTC held a series of listening sessions with market participants across various industries. So we did one in agriculture with grocery workers and farmers. We did one in healthcare with nurses and physicians. And so that merger revision project is also being directly informed with people who are speaking to, what's happened in industries where they've seen consolidation after consolidation. This is also really featuring in our criteria for how we prioritize enforcement actions. As you know, there are many more investigations and many more cases that are worthier of our attention than we can possibly take on. And so there are a few factors that we look at closely. One is, what is the magnitude of harm? How many people are being harmed? Is this a dominant actor in the marketplace such that the harm is likely to be pretty significant as well? Another thing we look at is if we don't act, who will? Especially with the Sherman Act, there's a private right of action, and oftentimes you have, big companies coming to you with problems that they're facing. And one thing we ask is, there's a private right of action. Are these players able to themselves bring a lawsuit? Because, areas where we're not likely to see private enforcement are areas where public enforcement is most essential. So hearing directly from the public is also something that's directly feeding into some of our considerations of what types of cases to be investing in and bringing.
Yeah, no, great. And so, in building on that, obviously you're working very well in partnership with other parts of government. So again, I think maybe it would be useful to just have an example of something that has worked well recently, where you realize that just leveraging your combined sort of forces helped in terms of outcomes.
Yeah, there are a few areas that come to mind. So some are instances where, the FTC and a federal agency will share oversight over consolidation or mergers. So for example, the FTC reviews defense industry mergers, and we last year successfully blocked Lockheed's attempted acquisition of Aerojet. That was an acquisition where we worked very closely with the Defense Department, in part because the Defense Department is oftentimes the biggest client, the biggest customer in these transactions, and so their perspective is quite important. But there's also been a reckoning within the defense world about how wholesale consolidation of the defense industrial base is actually leading us much less secure and has serious national security implications. And so the fact that the Defense Department and our partners there have been connecting the dots between concentration and market power and some of these other factors like national security has been enormously important. It's not something that we head-on can acknowledge necessarily in our reviews, but having their perspective can be incredibly important. We also recently signed a memorandum with our partners at the National Labor Relations Board. So these are enforcers that are enforcing the labor laws. And here we see a lot of overlap in the types of problems that we're seeing in some markets and the core problems that are emerging for huge asymmetries of power between employers and employees, or say platforms and the market participants that are dependent on them. And so those types of information sharing can be quite critical, because sometimes they'll see something where they don't have the exact right tools to go after it, but we might, so them putting it on our radar can help, or vice versa. So those are two partnerships that have been enormously important, as well as, again, our partnerships with the states. I think the states have been remarkable examples of aggressive antitrust enforcers, and I think it's really helpful to create some competition with federal enforcers and show us that if we don't act, others will, and that we really need to be working closely together to achieve shared aims. I will say in some instances, state enforcers have available to them remedies that we as federal enforcers don't. So sometimes states are able to more easily get back restitution or damages for harmed citizens, and so it can be especially important to partner back to make sure that the people who are being harmed are actually being compensated for that.
Yeah, no, I think it's really, really important to work with other partners, because in a sense you think about all the concerns coming to you, how many things you want to do, and the fact that the resources are finite, just being able to leverage the knowledge in other parts of government is really important. I mean, thinking about sort of operational capacity, obviously there are many enforcers here, and so everyone is always struggling with the fact that you have more things you want to do that you can do. You have limited budgets, struggling with attracting and retaining staff because of pay levels. I mean, what have you, in those initial 2 years, in terms of operational capacity, what are the type of key initiatives that you have pushed for in terms of just increasing your ability to just push for the program?
So there have been a few things. Recently, we were able to launch a new Office of Technology, which we're really thrilled about. The first year I was in this position, we piloted having more technologists on board and figuring out how can we embed these technologists across our agency, both on the competition side, on the consumer protection side, to make sure that throughout our investigations, we're fully grasping how technologies are working and making sure, especially when we're thinking about the relief and remedies that we might be seeking, how can we be, fully maximizing how technological shifts we can keep up with them and make sure we're fully grasping that. So that partnership has been terrific. We were able to recently formalize that as a standalone office, and we have a remarkable set of technologists already on board, including data scientists, data engineers, specialists in AI, specialists in really understanding, design ethics, and that's something that we'll be continuing to grow. Just within a few days of having job postings out for our technologists, we received somewhere between 300 and 400 applications. So this is an area where obviously we can't go toe-to-toe on the pay, but it's clear that there's a public hunger. There's a recognition that the work that we're doing is important and exciting, and we'll be able to continue to attract talent.
Yeah. Great. You mentioned AI. I mean, obviously, we've all spent the last few weeks talking about generative AI, new search engines, ChatGPT. I mean, I guess one of the issues we all have as enforcers is there's very important stuff that happens very quickly, and somehow you're always kind of fighting. There is a sense you're fighting yesterday's battles because obviously these cases take time and you need to collect the evidence and all of it. And I know you've always been very keen to try to, be really proactive in this space. So you have great powers because you have competition powers, you have consumer protection powers, you have privacy powers. I mean, what's your current thinking on AI and what you want to do to try to kind of be on top of the issues as they manifest themselves?
Yeah, this is really top of mind for us across the agency, and we've already been able to share some thinking on it publicly, especially on the consumer protection side, where we put out guidance noting that there are significant concerns with false and deceptive claims about the efficacy of AI. So sometimes we see claims that are not fully vetted or not fully reflecting how these technologies work. So there can be high error rates, there can be high rates of discrimination, and so we need to make sure that companies are not overselling or overstating their AI capacities. We're also now increasingly living in a world where AI can be used to create very realistic simulations. And that creates high risk of deception, high risk of fraud. And so that's something that we are also looking at closely. We recently put out guidance noting that the upstream developers of these tools can potentially be liable if the technologies that they're creating are effectively designed to deceive people. And so it's not just the downstream users that could be of interest to us, but even the upstream manufacturers. We're also thinking about this, of course, on the competition side. We just launched an inquiry into cloud computing, which I know many of our fellow international enforcers are also looking at closely. But as you have machine learning that depends on huge amounts of data and also depends on huge amounts of storage, we need to be very vigilant to make sure that this is not just another site for the big companies becoming bigger and really squelching their rivals. I think when you have these moments of technological transition, when the underlying technology or the underlying platform is potentially about to shift, that's when you see the incumbents start to panic, right? I mean, that's the lesson of Microsoft. That's the lesson, going back when we were seeing the shift from desktop to mobile, that you see the incumbents sometimes having to resort to anti-competitive tactics to protect their moats and protect their dominance. And so this is another transition that we're looking at closely to make sure that if this is an opportunity for competition to really enter the market and disrupt, that we're allowing that to happen rather than illegal tactics locking up the market.
Yeah. On private enforcement, you mentioned earlier, I mean, obviously there's a lot of private enforcement in the US. There's more into Europe at the moment as well. So recently, I think you've read somewhere that you're putting more resources into your kind of amicus program, again, trying to, I guess, leverage what's happening in terms of the private enforcement side. So do you want to tell us a bit more about, again, how you think about the cost and benefits of putting resources into different parts of the program?
Yeah, this is an area where, we have a list internally of what are areas of the law that we think are especially ripe for further development. So again, areas where we think there's some staleness or potentially some theories baked into the doctrine that we think are increasingly out of touch with how modern realities work. Areas where we think certain authorities have been underused, where we really want to be encouraging the courts to be creating and developing new case law. And so, there are more of those than we can possibly do on any given day or any given year. And so finding existing cases that could be vehicles for us to share our views is an important way to be basically increasing our impact. So that's something that we have a project internally underway to make sure that we're fully harnessing those opportunities as well. We've been pleased to co-sign various amicus briefs with the DOJ, with partners at CFPB and other agencies to be driving that forward.
Great. So let me conclude, given there are 30 international enforcers, with just a question about your views on sort of international cooperation on merger control and other matters. I mean, it seems to me, you've always tried to cooperate very extensively, the same way you do with the states here, with other parts of government, in a sense, with other partners internationally. I mean, it's obviously a bit more complicated at times because everyone has to deal with their own legislation, their own challenges. But again, what will be your reflection on your first sort of couple of years in terms of international cooperation on global cases, both in mergers and sometimes on the conduct side?
Yeah, I mean, the cooperation is phenomenally important, and it's never been stronger. We're so thrilled to have such close partnerships across the world, and I would say, there's the formal partnerships and the kind of formal cooperation and collaboration, especially when you have similar cases or parallel cases. But there's a lot that goes on behind the scenes and beneath the surface that's less tangible, but also equally valuable. And so I think those are some of the areas that we've been especially keen to be deepening, be it, sharing our experiences with, practically speaking, what it's looked like to build a technology office, or, identifying areas where we're both struggling with how do you perfectly, cognize this new theory in digital markets, and various enforcers are at different stages. I think we're also seeing a phenomenally exciting moment right now with various jurisdictions taking on the challenges of the digital age, and there are enforcement paths forward there, but there are also legislative paths forward. And so I think the kind of global experimentation that we're seeing is also incredibly important for us to all be in real time learning from each other and making sure that those lessons are ones that we're all heeding.
Great. Well, thanks a lot, Lynn. It's been super interesting, very exciting program. So I think it's, you're really doing a great job. So please, let's thank Lina for this great session. Thank you very much.
Thank you. Okay, great. So next we will be hearing from our esteemed AAG, Jonathan Kanter, as well as Tim Wu, who until recently was a special assistant to the president on digital matters and competition. Tim is, needs no introduction really. He is a foremost scholar on antitrust and has really been essential in resurfacing the deep threats to not just our markets and our economy, but also to our democracy that can arise when we see increasing concentration and monopolization. He was a key author of the executive order on competition that the president issued in 2021, and has been a key architect of ensuring that agencies are working together and we're pursuing a whole of government approach. So please, Tim and AAG Kanter, come to the floor.
Hi, everybody. It's great to see you and be back in Washington again. And, I thought I'd kick this off. This is an enforcers conference, and talk about enforcement policy. Jonathan, you're holding a job that, some very notable figures have held over the history of the United States. There have been times where the antitrust laws of the United States have gone into sort of a quiet mode. I think one of your goals has been to reactivate, or obviously never die, but bring a even greater level of enthusiasm and strength to the enforcement. And I just wanted to give you a chance to sort of sketch out your vision, any sort of role models you might have had in this job, and what you see as your primary goals going forward.
Sure. Thank you very much. And again, wonderful to see everybody. In terms of vision, I think, first and foremost, we're a law enforcement agency here at the Department of Justice. And our job is to enforce the law as our Congress wrote it. And our Congress made a judgment, a value judgment, that competition in the competitive process is important. Why? Because it is. Competition can yield a wide range of benefits for society and democracy, everything from lower prices to greater mobility of labor, to more innovation, to greater security and protection and resilience. And those are all beneficial values of competition. The genius of this approach is that our Congress concluded that by protecting competition and the process of competition, we can safeguard all of those different values. And so our vision, first and foremost, is to protect the competitive process and to preserve and protect competition, to identify violations of the law and to enforce. In doing so, it's really important for us here at the DOJ to make sure that we're enforcing all of the laws that Congress set out. And so what we've done is we've embarked on a journey to make sure that we are looking holistically at the full range of tools that have been set forth to protect competition. Some of those are familiar. Sections 1 and 2 of the Sherman Act, which address illegal agreements and monopolization. Section 7 of our Clayton Act, which addresses mergers. But we're also looking beyond, for example, to Section 8 of the Clayton Act, which is established in 1914 to prohibit interlocking board directorates, but has rarely been systematically enforced. We have embarked on the most systematic effort to enforce Section 8 probably ever, and that's already resulted in nearly 15 directors stepping off boards. We have nearly 20 open investigations and more to come. So this is just an example of the type of work that we're doing. At the same time, something you're quite familiar with, we've been unlocking competition policy and statutes across our entire government, whether it relates to air travel, healthcare, ocean shipping, agriculture and farmers, and many more, to ensure that we are taking truly a whole of government approach.
Yeah, let me pick up on that for a second. So one of the things that was a priority for the White House and this administration coming in was having the president speak very clearly and forcefully on what this administration, what he felt antitrust and competition policy should be, leading to the executive order on competition. And I wonder, from your side, seeing it as law enforcement here in the Justice Department, I wonder if you could say whether it's been useful to you to have the president involved, have the competition, have the executive order out there, and whether it's been useful to have other agencies tasked or asked to be more active in their pursuit of competition policy.
So the executive order has provided an invaluable framework for competition policy. I don't think, in my memory, we've ever had that level of wind in our sails and support from an administration that said this is not only a priority, but it's a priority for the entire government. And so within that policy framework, we've set forth here at the DOJ to make sure that we are developing a vibrant enforcement program. And so the reception that we've received from other federal agencies, for example, has been unprecedented, whether, again, it's in the area of healthcare or agriculture or aviation or labor. The receptivity to competition policy and tools, the willingness to look at laws and tools that have existed sometimes for decades or even over a century, but have rarely been used and enforced. Now we have all of those tools available to us as a whole of government, and so it has really, in my view, unlocked extraordinary potential to help preserve the competitive process.
Well, thanks for that. I want to also pick up on something you said about rebooting or reactivating either doctrines or statutes or areas of the law that have sort of fallen quiet over the last 40 years or so. You mentioned Section 8. Other doctrines like predatory pricing, in the United States at least, seem to have become a lot quieter. I wonder if you had examples or thoughts, if you're willing to share with us ideas about areas of the law you think are sort of ripe for reactivation, or where areas you see as priorities.
Sure. So I think we've talked about a number of areas that were ripe for reactivation. Again, these are rules and laws that have existed. So we mentioned Section 8 of the Clayton Act with respect to interlocking board directives. The Department of Justice bringing enforcement actions under the Packers and Stockyards Act. We've talked about since the first time since 1977, when I was 4 years old, we brought criminal monopolization cases under Section 2 of the Sherman Act. And so we are reviving those doctrines. We have more open investigations and litigation under Section 2 of the Sherman Act than ever before. The other piece that we're trying to make sure that we are addressing is reflecting market realities. And this is a theme that I think you've heard since I took office, and I know this is something the FTC talks about quite a bit as well. But understanding how markets actually function and then working backwards from that. Tim, you and I have talked in the past about what motivates corporate behavior. And so what motivates corporate behavior today is different than perhaps what motivated corporate behavior 30, 40, or 50 years ago. It is undeniable that business decisions today are motivated in large part by maximization, sometimes long-term maximization, sometimes short-term maximization of share value or valuation. And while that at some point can reflect profitability, short-term profit maximization, long-term valuation, or short-term share valuation maximization do not always align perfectly. And that factors into decision making. And I think it's really important that we understand how decisions are made, understand the reasons they're made, and understand the technological changes that go into decision making to ensure that we're being effective.
Is predatory pricing possibly an example of that? An example where you think
Absolutely.
maybe well, go ahead.
Yeah, and so predatory pricing, is built on this assumption that certain conduct is not rational for short-term profit maximization. But I think it's quite clear that long-term share price or valuation maximization often deviates from short-term profit maximization. And if you think about this, how do most of the richest people in the world generate their own personal wealth? It's not through often profitability, it's through share equity and share price and growth in share price. And so when people are making decisions in a business that are designed to maximize their personal wealth, it leads to a different set of criteria, a different set of incentives. And it's important, without saying whether those incentives are good or bad, it's just a fact. And so these are facts that I think are really important for us to understand.
Right. So you're saying people like to be rich. The way you get rich is by having a high share price, and so whatever's going to do that, including short-term profit, is maybe the thing you should be looking at. And I think that speaks to a broader theme that you've had explored on earlier times, which is the importance of understanding business from business's perspective. And I want, what I mean, and I'm from a business studies, and I wonder if you can elaborate a little bit on how in your running of the office you may have prioritized that, or how that comes to make you see things differently, hire different types of people, that sort of thing.
Yeah. So, as I look out and I see our fellow enforcers, the talent among lawyers and economists is almost boundless. We have some of the most extraordinary enforcers that I've ever had the opportunity of working with, both internationally, and then when I think about the Department of Justice, perhaps I'm a little partial, but I've just been continually throughout my career, and even more so since joining the Antitrust Division, constantly amazed and blown away by the extraordinary level of talent and dedication that exists. I think as we think about expanding to meet the demands of a modern economy, it's important that we expand the spheres of expertise that we have. Right. And so we are, for example, if you think about many of the great economists in our world, they don't just teach at econ departments, they teach at business schools. Why? Because it's important to have the access to the information, to the dialogue, and to this expertise from various kinds of experts throughout our economy. And so we are building, for example, in our expert analysis group under the leadership of Susan Athey, what we call a business school faculty style of organization, where we have expertise that includes not just some of the best PhD economists in the world, I think the best PhD economists in the world, in my opinion, but also data analysts, data scientists, banking experts, healthcare experts, agriculture experts, business strategy experts. That's the kind of institution that we are building, which we believe will help us be even more responsive to the market realities that we confront on a daily basis.
I mean, maybe it seems self-evident, but maybe you can give us an example where that change in emphasis matters. Why you think the business perspective might differ from maybe a more abstract sort of economic perspective, given that they're both economic at some level, but what does it mean to be a sort of more business as opposed to economically focused?
Yeah, I think it's understanding what motivates behavior and how businesses operate. So let's take, tech is often, I think, an important part of the conversation. Well, what are the most profound changes in technology today? Well, they relate to data and AI. This is not a reaction from us over the last 3 weeks, but for over a year, we have been building core competency in the area of artificial intelligence and expertise. We've brought in data scientists, AI experts, and others to make sure that we have the deep technological understanding of these technologies so that we can be appropriate in how we enforce the law. When we think about these technologies, just to be clear, we're not making a value judgment about whether they're good or bad. We're simply saying that we need to understand how they work. Right. We need to understand where the potential competitive choke points exist to ensure that we're enforcing the law effectively. To me, that is the most crucial piece. Yeah. We're doing something similar with respect to healthcare and banking and agriculture to make sure that we have that deep understanding.
Sure. I want to get back to AI in a second, but this wouldn't be an enforcer summit if I didn't ask you how you decide to bring cases. That's part of the most challenging, sort of the most interesting part of the jobs. What to green light, what maybe to hold back on. I wonder if you have an approach, maybe a formula, possibly an acronym.
It's funny you should ask. So for starters, again, I want to be very clear. We're in a law enforcement agency, and so we focus on conducting investigations to detect violations of the law. And when we detect violations of the law, we believe that we can sustain a case in court. That's when we bring a case. But I think it's also, clear that the concerns that we confront are so vast that it's very difficult for us to allocate our scarce resources. And so we think internally on the team, we talk about keeping our hands on our hips, hips standing for high impact, programmatically significant. And so when we think about what matters and most important to us, we're thinking about first high impact, what affects the greatest number of people, the economy, our democracy, our core values. And then we also think about issues that are programmatically significant, meaning that they have a meaningful impact on the direction of the law. And so that's just a generalized framework that we apply to make sure that we are using our resources in the most effective manner possible.
Well, let me get to this AI question. The Department of Justice has been facing new technologies since it sued AT&T in 1911. So it's been a long history of taking on challenging new technologies. I think it was 1911. And in any case, one of the things that's in a lot of people's thinking right now are the challenges from AI and the potential challenges. Also, you talked about the market power of data. I wonder if you had any thoughts to share on how you plan to approach some of these challenges, particularly the challenge of AI.
Sure. So, I often think of the famous avant-garde composer John Cage had a saying, which is, structure is a glass into which anything can be poured. And so when you think about AI, it is a technology, a transformational technology, but a technology nonetheless. And we've experienced many transformational technologies throughout history. It might be the factory, and it might be telecommunications, it might be the personal computer. These are all really important, and the microchip. developments that transform society. AI has a very significant potential to do the same. And the opportunities, just like the challenges, are boundless. And that's a good thing, but also can be used for a force of good and for bad. And so our job as competition law enforcement authorities is not to make judgments about whether it's good or bad, it's to make sure we understand the competitive landscape. So when I think about AI, for example, there are a few different dimensions. First is, well, what does competition look like for the technology? And so that might mean access to data sets, it might mean API access, it might mean access to the physical and hardware infrastructure necessary to run the kind of compute necessary at scale. We think about also potential choke points and tipping points. And when we think about AI, it is inherently dependent on scale. And so markets that are inherently dependent on scale often present a greater risk of tipping, often a greater risk of having deep moats and barriers to entry. And so it's really important that we understand that. Then there's the second dimension, which is not just competition for the technology, but it's competition in light of the technology. And so when we think about the applications for AI, it's just like a factory or a microchip or software which can be deployed in so many different contexts. And so when we understand when we try to understand how markets function, what market realities look like, we have to factor in that these technologies are going to be deployed. And again, that may create lots of opportunities, but also it may create lots of challenges from a competition perspective that we need to understand and address.
I appreciate that. I think we're running into the last few questions. I want to bring up something. Lena had mentioned democracy earlier on. One of the things that President Joe Biden made a big deal of in economic policy was the ability to explain it to the public. If you've seen Joe Biden speak on economic issues, he often relates it to the kitchen table. How are people really taking this? Now, antitrust has come in and out of the public imagination. It's often extremely technical, challenging topic. It's difficult to explain the workings of Section 7 to the average member of the public. Maybe not possible, but challenging. Do you think it's important that antitrust be something that is conveyed in a way that the public understands? Do you think that it's a duty of Justice Department and the FTC to make it clear what you're doing and why? Or is it more important that you sort of have the room to do what's technically important in your own space?
When antitrust and competition law become too technocratic for the general public to understand, then it's too technocratic. Right? Congress wrote our antitrust laws as generalized statutes for citizens to understand and appreciate. They wrote statutes to be enforced in court in front of juries of the peers. We have an obligation to make it accessible. We have an obligation to make sure that the public can relate. Why? Because the public demands competition. They may not use the words and the acronyms that we use in this room, but when I talk to people in the general public, do they care about the opportunity? They care about the opportunity to work where they want to work, when they want to work. They care about the opportunities available in their local communities and the geographic dispersion of opportunity. They care about freedom to have a great idea, to start a business, and to have that business succeed. Opportunity and competition go hand in hand. That is something that the public deeply understands. And if we fail to understand that, then we're not doing our job.
Well, let me follow it up. Another theme of the president's, and I guess I've obviously not been out of the White House that long because I can still remember these talking points. But another theme of the president is very important was trying to make the economy work for everyone and try to reverse the impression that we built an economy that primarily existed to enrich the existing elites and particularly coastal regions. I wonder if you've thought of antitrust as being an important part of that program. I know the president certainly did. And in what ways you think, you had just brought up opportunity, you think that antitrust plays a larger social role in trying to ensure a sense that the economy really does work for everybody?
Yeah, it's long been a fundamental core of antitrust enforcement that competition in the marketplace and democracy in the polling place go hand in hand. And we need an economy that has the opportunities for everybody across the country. We need truly a meritocracy. When only the big are capable of getting bigger because of barriers to entry and moats and scale, that is not an economy that is working for the entire population. When I think about antitrust enforcement and competition policy enforcement in the United States, I think about the opportunity of farmers who are small business owners, sometimes medium or large business owners, to have control over their own destinies. I think about entrepreneurs, not just on the coasts, but entrepreneurs throughout our entire country and our brilliant university system and our local and both rural and suburban communities having the ability to bring great ideas and build those ideas where they live, where they want to live. When I think about the needs of employees and the rights of employees, people who work hard to have the opportunity to work and have the mobility, that to me is what the American dream is about. Growing up I always thought about, well, what is the American dream? To me, it was the ability to own your own home and to start your own business. And I believe that is truly at the core of what we are as a country. And I believe that competition and opportunity go hand in hand. And without sufficient competition, there won't be sufficient opportunity. And without sufficient opportunity, we're going to have the kind of divergence between the haves and the have-nots. And that is not okay. We need to give people the chance to compete. We need to give workers, consumers, entrepreneurs the chance to benefit from competition. It's not about picking in winners and losers. It's about making sure that everybody is invited to compete in the game.
I'll add to that. It's sometimes thought of antitrust as when it was born in the early 20th century, as a more intermediate road, as opposed to a communist or an anarchist or a dictatorship-style solution. So there's something in what you've said historically about antitrust being a leavening of capitalism. Let me pick up on two things you've said already. You've talked about antitrust as being important for protecting opportunity and the sense of the vision of an economy that can work for more people. You've also talked about antitrust and its role in defending and protecting the competitive process. Those seem like slightly different formulations than some of the formulations we've heard for the last 40 years, which have more often focused on consumer and consumer welfare. And I'm interested in whether you think this marks a divergence, an evolution, or how you see, maybe state more clearly, the goals of the antitrust laws.
Sure. I mean, I think it's, I'll leave it to others to determine whether the diversions exist or not. I try to, and this picks up at a theme from the previous discussion, I try to remain faithful. I think we try to remain faithful to the will of Congress, right? And so, this is really important in our country, which is Congress writes the laws and we enforce the laws. Congress made the value judgment that competition is important. Why? Because it promotes democracy, because it promotes opportunity. And our job is to enforce it for that reason. And I think when we run a real risk if we start to import our own value system and say that only harm to one constituency matters. I think competition, again, can benefit consumers, and the welfare of consumers is absolutely essential to enforcement of competition laws. But so is the welfare of workers, so is the welfare of entrepreneurs, so is the welfare and the impact on our democracy. All of these and many more are attendant benefits that flow from competitive process, which why, to me, it's important that we protect that process and let those benefits flow.
That's very helpful. One of the things I want to pick up on that seems to have gotten a little more interest and traction in the United States than internationally is the topic of labor interests or employee interests in antitrust. You won a case, the Random House Penguin merger case, which was really centered on a labor theory or an employee theory. And I wonder if you can say just a little bit about labor interests and labor values, or even the analysis that goes into it, and how you think they might affect the antitrust law going forward.
Sure, I think it's recognizing that competition isn't one-dimensional. Anybody who's ever looked for a job, anyone who's ever tried to get a better salary or better terms in the workplace understands that competition among employers yields a wide range of benefits. That, to me, should not be controversial. It should be foundational to what we do. And so that, to me, is a fundamental element. When I think about the Penguin Random House case, I think about a few dimensions. One is the recognition that a merger can affect competition upstream, meaning it can affect workers, laborers, input suppliers. But that case was important for other reasons as well. We're talking about authors. Right. And so we often talk about the relationship between competition and democracy. Well, free speech, free flow of ideas are foundational and fundamental to the political discourse of all ideas across the political continuum. And it's absolutely essential that we are preserving competition for those ideas. In the case that we're discussing there, it involved advances to authors. And contrary to the positioning of some, these are authors, many of whom depend on advances to pay their bills, to send their kids to school, to save for retirement, to afford health care. And those advances are necessary for them to do the research to write a book, often which can take years. And we want competition for authors. We want competition for ideas. We want competition to allow the free flow of information in a democratic society to reach all people.
Thank you. We have obviously an international crowd here. I wonder if you want to comment. We've spoken mostly about the domestic program, but on aspects or anything you want to say about the international program of the Department of Justice.
Yeah, it's really exciting. It's really exciting to be in this room. I look out and I see an extraordinary group of people internationally and among state attorneys general, many of whom have become dear friends in the process. And we live in a global economy. We live in economy with local impacts. And it's really important that we have an open and rich dialogue among competition enforcers at the global level and at the local level. Why? Because enforcement affects real people. It affects people abroad, it affects people domestically. And we can learn from each other. We must respect our sovereignty, and we must respect the sovereignty of others. And so it's not about farming out decision-making. We still make our own decisions, we still reach our own conclusions, we still enforce our own laws. But we can benefit greatly from an exchange of ideas, especially when the impact and the information is so broad in some sense and so localized in others.
Any last things? This is our last question. Any last things you want to touch on that I might have missed?
No, I think just that we've seen a lot of success. I'm a little over a year in my position, but I look forward and I see a lot of work to do. And we're living in a transformational time. And I truly believe that when they teach about competition law and competition law enforcement 100 years from now, they're going to talk about this moment as being pivotal. They're going to talk about this moment as being an inflection point. I think we have an obligation to make sure we're meeting that moment.
Well, I hear that. Thank you much. I think there's no going back, and congratulations what you've done so far. Congratulations in advance on what's coming to come. What's to come.
Thank you.
Very much.
Well, everyone, it's time for our morning break. A few administrative announcements just before we do actually break. The first is that if you haven't found the coffee, it's in what's the green room, which is the inside of our old credit union where you used to be able to cash your checks if you were a DOJ employee. Second is that anybody that is looking to use the restroom or go anywhere else in the building will need to have an escort. That's fine. We have an army of them in the back, and they're prepared to take you where you need to go. So if instead of coffee, you guys are in the mood for a triple shot latte, we have a coffee shop downstairs. Someone could take you there. So just please ask. But otherwise, we are going to break until 10:45, and we'll see you back here.